Good morning, good afternoon, and good evening, everyone. Welcome to this International Archives Week 2026 online case study session, Archives for Accountability. My name is Maria Paula García Mosquera, Head of Communications and Partnerships at the ICA, and I'm delighted to welcome you today on behalf of the ICA. This session is part of this year's International Archives Week theme, Archives for Justice, Rights, Memories, and Futures, which invite us to reflect on the vital role archives play in supporting accountability, transparency, and access to information. Over the next hour, we will hear a series of case studies from IC members around the world who will share their experiences, challenges, and lessons learned from projects that demonstrate how archives contribute to accountability in different contexts. One housekeeping recommendation. For those who would like to read or to listen to this session in other languages, we invite you to activate the closed caption options at the bottom of your screen. Also, if you have questions or comments on the presentation that you will hear in the next hour, please use the Q&A box to add them there so we can address them after each presentation. Now, I will thank you everybody again for joining us. And without further ado, let's begin the session. So it is my pleasure to introduce our first speaker, Raji Abdul Salam, who will present the case study titled From Testimony to Accountability, Building the Reckoning Archives for Justice. So Raji, the floor is yours, if you can activate your camera.
Thank you so much for having me, and greetings for the audience. So basically, I will start sharing my screen. So basically, I just want to talk quickly about the Reckoning project and the needs that force us to format it in this way. So basically, one of the biggest challenges is in our work is to follow up with people, the people aspirations, and at the same time to make it usable in courts. So one of the things that we are trying to, as much as we can, to create within our archive is the ability to use something that is admissible in court, but at the same time have some of the respect that the humans within this archive, the human element, is being respected and protected. And for that, as we will see later, this is how we formatted the actual infrastructure and the actual archive. So one of the things that we have in our archive, it is a human-centered testimony-based archive. So we have a very strong element of humans within it. And at the same time, you have to deal with them in a way that it's respectful, it understands their trauma, it understands the identity protection, and at the same time, it keeps the infrastructure or the actual variables that is needed within within a certain jurisdiction. And here we are talking about International Criminal Court or universal jurisdiction or the national court within a certain country that we are active in, like in Ukraine or in Sudan, for example, previously in Syria. and recently in Gaza. It's a different jurisdiction, different type of courts, and everyone has a certain standard that you have to have when you are collecting a certain evidence that could be a human testimony, and sometimes what we call the supportive evidence that could be a photo, it could be a DNA sample, it could be sometimes a medical report, an actual document, or a documentation that another entity brought to our attention. So the thing is how to balance something that is so sensitive, so virtual as a human testimony and related supportive evidence, and at the same time to keep it admissible in a very rigid systems like courts and international jurisdictions or universal jurisdiction. So what we try to focus on is the respect of the human being and their entity, and also the respect for their wishes and and the level of consent that they give us, so we are able to use such a documentation. Here I'm talking basically about how we can do that, what is the major arguments that we face within the archive. Before, my work was very ontological. That means I'm archiving for the sake of archiving because there is a value in the history. And if I look at in the way that I want to see something that is humane, then I would say, okay, there is a collective memory I'm trying to understand from a very humanity-based academic, like anthropological value or historical value. But when we brought it to the court and when we were faced about the crazy atrocities, when you are working in a conflict zone where there's a war crime or a crime against the humanity or a concern of genocide, the complexity of the thing started to be very, very demanding. And at the same time, it's very easy when you are working with the vulnerable groups that you somehow think for them. And this is something maybe it's very bad, as we can see later in later examples, if we have the time for that. So basically, what we are trying to do, we are trying to bring to the attention of the world, and at the same time to preserve the access of justice for a certain populations that they are suffering under a conflict. So basically, what we are trying to create that this design that is not so pedantic and it's full of administration, rather than it has a complete set that fill in the junctuality of being part of a justice admissibility. So the big question is, when we are talking to a certain population, and every population we work with, they have their own version of justice, their own ambition about what they want to do, and their own resilience that they will invest within us as a reckoning, and we will be part of that resilience to help them go through that difficult times at the same thing. So how we work on that and with whom? So basically, we work with people who are under the law or they work within the law, like court, judicial system, quasi-judicial system. But sometimes the court itself, if there's no political will, they don't want to push for that thing. And this is something we saw a lot in Sudan and in Gaza, for example. So what you do about that, we go for the public court, the public opinion court, and here we work with journalists. And sometimes some of the population, they are not interested in the big thing about courts or public opinion. They want to understand what happened to them. They want to collect their own memory to create this collective memory that goes and tell them and help them to transition from state of chaos or state of war to something more peaceful, more of a social cohesion part. So we have to respect that, and we have to respect that wishes. And for that, when we created our archive, it has its own specificities within each population. In Ukraine, it's totally different of what we do in Sudan. It's totally different of what we did in Syria, or what we are doing and will do in Gaza and West Bank. So Oh, this is something very beautiful. So basically, every archive, it has its own infrastructure. Within the times that, in my old days, I'm not so old, but somehow I have like 15 years of experience working in this domain. So in my days, we had this era of non-digitized evidence. We had this old way where the books were kept in a format called déjà vu. It's a very, other colleagues maybe they know it. The younger generation, they don't know it. So at that time, we had a totally different approach when it comes to how to preserve books, how to preserve testimonies, how to preserve oral history. Uh, Now we have the ability to digitize everything. And here we have the biggest challenge when you want to digitize something, because there is a consent between you and the population or the persons that give you this legal responsibility and liability when you are doing that. At the same time, you have to keep in your mind that if you want to go to a court, everything that you use and you preserve, it has to be in a state of immutability. At the same time, some people want to do analysis with it and want to use it. So you have to always keep the balance of keeping this immutable digitized version with a clear metadata on how to bring this from step A to step B, and how to protect the actual people inside this archive, and at the same time keep it admissible to a certain jurisdiction or a certain study if it is needed to go that way. So the trick is we deconstruct a certain unit, we have it. If it is a record, if it is a photo, if it is a video, if it is a testimony, and at the same time, we reconnect it or reconstruct it in a very digitized way that is kept as a holistic entity. So sometimes you need this piece of it, sometimes you need the whole package of that thing. I was just talking about that. So the record is a continuum. Each piece of it has its own meaning and its own purpose, and at the same time, they all act together to create the big picture. Why we do that? Sometimes it's for protection. You don't need, sometimes you have to redact the actual name of the victims because of the gruesomeness, or because they are still under occupation or under danger. Sometimes because there is their own wish not to be mentioned. Sometimes you need to not redact, to simplify a testimony that, or a record that is 60 pages, to something that is very concrete. Then we have a certain methodology called the CCC, correct, concrete, coherent, where the whole testimony, it's got summarized to one page, where a certain contextual element of crime that the legal team would need. There is some kind of a human story that the journalist or the anthropologists that are working on that they need, so each part has its own uniqueness and its own purpose, but at the same time it always play a very vital piece for the whole holistic case, or the case file that we are working on. Here I just went quickly about the archive and its value and its functionality. So basically, anything we have to bring to our archive has to be verified, and at the same time, it has to have the respect of what we collect. So there's no prejudice, there's no biasing. So even when we are collecting something that goes to the court, one of the funniest stories, and when people are so traumatized, they tell you things that is impossible. Like, we have a person that got tortured so many times that she lost their sense of self. They got something called dissociation. So they were looking at themselves while they are being tortured. So when they describe the story, it makes no sense from a legal value, but we have to record it correctly in this way. Then when we go for the concrete verse, we restructure it as a fact base. And we talked about this, that he or she felt, and this goes for a certain thing that goes specifically to describe what they felt, why they felt it. It was 1, 2, 3. And then that part or that piece goes all as a part and go against other part. Against is not like against, but basically we compare it and we see how it works with other things related to that specific testimony. And this is the coherency. When you do like some vetting against the supportive evidence, against DNA samples, against other medical reports, in such cases, against the destruction photos that you have before or after.
Raji, this is just a reminder that you have 1 more minute.
Okay,
We can move to the questions.
Okay, then I will just talk quickly about preserving the chain of intellectual work. And this is basically, okay, so not to take more time, the thing is the most important value that we have is why we do it and who is the owner of that thing. So within the recording project, we do things because the ownership goes for these communities and societies. And what we do is we somehow give them the promise to preserve their access to justice, the justice that they want and they need. I'm going to stop here. Thank you.
Raji, thank you so much for sharing your experience and the insight of this project with us. We received one question in the Q&A and it's from Tara Gunn. She said, Tara, I am in the United States. Have you encountered any issues with obtaining archival materials these days from outside your boundaries?
I would ask her to rephrase the question in a way I can understand it.
Tara, could you do that for us? Or maybe give us more context on your question? Because maybe, yeah, is also like, I guess that she's curious about like if what is like the problems or the issues, like in case you are obtaining material like archival material from like places outside your outreach.
Okay, so basically I will try to rephrase the question as I understand it, and I hope I understand it right. So when I have a material that is alien from my archive, that means it's not collected under my own methodology or does not adhere to a certain procedures and protocols. And that would happen a lot when you have a partnership with other organizations or other entities that they would have something of value. So one of the biggest challenges in that thing is the consent and the consent and the consent. Who give me the consent to use that material? And the second thing is the difference in methodology. So to me, before I actually take anything from any other entities, I have to make sure that there is a consent that I can use it and I can look at it. And the second thing, I need to know their methodology when they collected this specific materials. And from there on, we try to respect the people's need and we try to use it. For example, in the case that we built in Argentina, 2 of the witnesses that were involved weren't part of the archive that we did. Another organization, sister organization, that could reach these people. So what we did, we have to repeat everything with them because the methodologies that they used, it was bit different. It did not take in consideration the physical and the mental fitness of the witnesses, the degree of trauma they have. And at the same time, you have to make sure that you don't bias them, you don't contaminate the actual evidence that they would talk about. So it is a challenge, but as long as the sincerity there, the consent there, and understanding of the methodologies that the information was collected, it is manageable.
Great. Tara just said that is exactly what she was implying. So I think that this is perfect. So thank you again, Raji. And now we will move to our next presentation. It is my pleasure to introduce Tola Peang and Ruth Whittaker, who will present Transforming Records into Justice, Archives and Accountability at the Extraordinary Chambers in the courts of Cambodia. So Tola and Ruth, the floor is yours.
Good afternoon. Good afternoon, everyone. Thanks for joining us. Let me share my slide. Okay, my name is Tola Peang. I'm a record and archive officer at the extraordinary chamber in the court of Cambodia called ECCC, joined by my British colleagues, Ruth Whittaker, who support the work of the court via the United Nations. Today, we would like to share the experience of the ECCC and in particular how archival supported the legal accountability during the Khmer Rouge trial. I will first introduce the work of the court, how it relates to archive and the provenance, and Ruth will continue speaking about what we call judicial provenance on how archive will transform into evidence. Well, let me give a quick brief about the ECCC. ECCC is a hybrid tribunal established under the within the Cambodian legal system to prosecute the senior leaders of democratic Cambodia and the most responsible for the crime they committed during the Khmer Rouge period between 1975 to 1979. During the judicial past, the court accumulated a vast body of record which developed and now form the part of the ECC archive. The ECC archive today, it's up to now, the ECC archive contains more than 232,000 documents, totaling more than 2.5 million pages of the material in Khmer, English, and French. Well, the focus of the today's presentation is not only about the size, the accessibility, or the preservation of the archive. Instead, we would like to explore a different question on how do archive records become legally operative evidence. In other words, how do material move from history to evidence and from evidence into judicial reasoning? This question really sits on the point of the relationship between the accountability and the archive. Well, many discussions about archive focus on the preservation, the access, the digitization, and so on. Of course, they are very important. However, from ECC experience showing that the legal accountability does not just depend on preserving record. It's also depend on the structural process through which those records are examined, accessed, and used as evidence in the courts. The ECC therefore provide a useful case study because it showed that archive do not automatically generate the accountability. Instead, the accountability emerged through process that transform archival material into evidence capable of supporting judicial finding. To understand this, it's useful to begin with the concept of the provenance. As many archive professionals will already know about the traditional meaning of the provenance, which concern about the origin and the context of the record. It's asked who created the record, why it was created, and how it has been preserved and transmitted over time. Many records of the ECCC originated during the democratic Cambodia in between 1975 to 1979. Those records included the internal communication, telegram, policy document, etc. And after the collapse of the Khmer Rouge, this material were recovered through different pathways. Some remain at the site of the S21, other into the custody of the museum, archive, researcher, or documentation center. In many cases, records survive only a photocopy, copy of copy, or digitized reproduction. Some original were completely lost. As a result, many records arrived before the trial chamber with a complex, fragmented, or incomplete custodial history. This raises the important question concerning the provenance, authenticity, and the reliability. So for the purpose of this presentation, it's also useful to distinguish a second form of the provenance, what we call judicial provenance. Historical provenance as where a record came from, while the judicial provenance as what happened to the record once it's entered legal proceeding. This distinction is important because the record did not automatically become evident before court at all. Instead, they underwent a structured evidentiary process, which my colleagues Ruth will look at next.
So, as Tola mentions, there is a difference between historical provenance and judicial provenance. So, whereas historical refers to where the records come from, the judicial provenance asks what happens to those records once they enter legal proceedings. So, firstly, parties would submit proposed evidence lists, as you can see on the slides there, and these lists identify the materials that they wish the trial chamber to consider during proceedings. Secondly, the chamber decided whether those materials should be admitted. And as a general rule, relevant evidence was admissible unless there were reasons to exclude it. And materials could be rejected if they were irrelevant, repetitive, unavailable in good time, or otherwise unsuitable according to the internal rules of the court. It's also important to notice that admission alone was not enough. And in order to be relied on, evidence had to be formally introduced through identification in court and without any successful objections. So in other words, put before the judges during proceedings. Once a document was admitted and put before the chamber, it was assigned an E3 number, and this marked it as part of the evidentiary record that the chamber could rely on. It is important to note that not all documents acquired this designation, many were never introduced at trial, and not all E3 documents ultimately influenced judicial findings. This highlights a very key point, which is that archives contain records and courts assess evidence, and although those concepts overlap, they are not identical. And admission didn't determine the weight that the chamber gave to evidence. So even after evidence had been put before the chamber, things like reliability, authenticity, corroboration, and context still had to be assessed. And this is very important to remember. Because the weight given to these documents and the role that they ultimately played in findings depended on further evaluation. So moving on to the next slide, the chamber there assessed probative value, which means how useful a particular piece of evidence is in helping to establish a fact. And when the chamber assessed documentary evidence, it considered a range of factors, some of which we've noted on the slide there for you. And things like provenance, chain of custody, consistency with other evidence, whether the document was an original or copy, all these factors were important to consider. And very importantly, the absence of an original document did not automatically prevent the chamber from relying on a copy of it. And given the fragmented survival of many records from the Khmer Rouge period, the chamber assessed documents in context. So this contextual approach can be seen in one case study, which is that of the treatment of the Tram Kak district records. These are a collection of notebooks, reports, and prisoner lists, and other records that were created during the Democratic Kampuchea period. They survived largely in photocopied form, and they are a very important example of how records with incomplete chains of custody could still be authenticated and still relied upon through corroboration and this kind of contextual analysis. During proceedings, the defense challenged the Tram Kak records on the basis that many originals were unavailable and that the chains of custody were incomplete. The chamber acknowledged this, but examined the materials holistically. And instead of treating the quality of chain of custody as conclusive, it assessed whether the documents were corroborated by witness testimony, contemporaneous records, layout consistency, and other evidence before the chamber. And in doing this, it concluded that the collection could still be treated as reliable despite imperfections in its custodial history. The court's approach here demonstrates an important lesson, in that the chamber did not simply ask whether or not a document existed, and it asked whether there were sufficient reasons to rely on it. And a similar contextual approach was applied to testimonial evidence. During proceedings, the court heard from witnesses, experts, and also civil parties. Civil parties were victim survivors who participated in proceedings as well. And again, their testimony was evaluated through consistency, corroboration, credibility, and comparison with other evidence. So documentary evidence and testimonial evidence were assessed together as part of a broader evidentiary framework. As a very brief side point, because authenticity and reliability of the records were central concerns throughout the proceedings, language became an important evidentiary issue because the proceedings were conducted across 3 languages: Khmer, Cambodian, English, and French. And the chamber recognized that these processes could introduce complexities because much of the evidence entered the record through processes of interpretation, transcription, and translation, as you can see on the slides there again. Although those processes were not formally treated as distinct categories by the chamber, they did have implications on how evidence was assessed. The key takeaway here is that the court approached translated and transcribed materials with great care and often considered them alongside original language materials and other supporting evidence. This does lead us to what may be the most distinctive aspect of the ECCC's archive, which we can explain through the concept of judicial activation. So a record may exist within an archive for many years, but it acquires a new significance the moment that it becomes part of judicial reasoning. And under this approach, activation didn't occur simply because a document was preserved or put in an archive or because it was admitted into evidence. That judicial activation occurred when the chamber actually relied on that material in reaching its factual findings and legal conclusions. So it is at that point a historical record became part of the reasoning process by which criminal responsibility was determined. And this concept helps explain why the ECCC archive holds a unique value compared to other institutions that also preserve records relating to the Khmer Rouge period. The ECCC's archive isn't to claim exclusive control over these materials, but it is still very different. And what is important to note, as we've highlighted on the slide there, is that the court's task wasn't to document history. Its task was to adjudicate criminal responsibility. So the archive preserves not only historical records, but the judicial scrutiny through which those records were evaluated. And it preserves that relationship between evidence and judgment. So in this sense, it is a preservation not only of the records relating to the events that were examined by the court, but also the process through which the chamber reached its legal conclusions. It shows how evidence was gathered, tested, and relied upon in determining responsibility for crimes committed during the Khmer Rouge regime. And it also preserves the reasoning behind the legal findings, which allows that very complicated judicial process to remain visible and open to scrutiny. If we can move on to the next slide, we would like to conclude with one final observation. And it is that the ECCC shows that archives are essential tools of accountability. But accountability does not arise automatically from the existence of those records. Those records become meaningful within the legal process through these processes of admission and examination, challenge, corroboration, and judicial assessment. And the experience of the court is therefore useful for other courts, for truth commissions, and for accountability mechanisms more broadly, because it shows that archival records don't automatically produce that accountability. They have to be subjected to judicial scrutiny, and they have to be incorporated into that legal reasoning. And although other mechanisms might use different procedures, the broader lesson is the same. We have to examine these archival records through an appropriately structured and transparent process. So that concludes our presentation. We are happy to take questions now if there's time, but what we would like to emphasize is we have left our email addresses on there in case anybody has any detailed questions for us, which we'll respond to later. And equally, if anyone present today would like a copy of these slides, just let us know.
Yeah, we have 1 minute, so I'm not sure if somebody has one question, but I would like to thank Tola and Ruth for that fascinating presentation and for highlighting the important role archives play in supporting accountability. So they will add their email in the chat box in case you have a question. So knowing that we have 2 more case studies, let's now move on with our next speaker. Thank you, Tola and Ruth again. So we will pass to our next speaker, Cecilia Jazmín García Novarini, who will present the presentation titled "The File Hidden Among the Clothes, Recovery, Authenticity, and Best Practices in Documents on Human Rights." Cecilia will speak in Spanish. So if you have not activated the closed caption options, please do so you can read the subtitles in the bottom of your screen in the language that you prefer. Cecilia, muchas gracias. Y la presentación, Zoom, no sé cómo decir la expresión, the floor is yours in Spanish, pero bienvenida y esperamos que tengas estos 10 minutos para tu presentación y que todo vaya bien.
Muchas gracias, gracias al Consejo Internacional de Archivos por esta posibilidad. Pido disculpas por hacer la presentación en español cuando sugerían hacerla en inglés, pero justamente para poder llegar con los 10 minutos me resultaba imposible poder sintetizarlo esto en inglés. Por suerte la tecnología nos permite estar más cerca. Hoy vengo a presentarles un estudio de caso que condensa uno de los mayores desafíos de nuestra profesión en contextos de justicia transicional, que es justamente cómo transformar aparentes fragmentos documentales en evidencias judiciales. Hoy voy a presentar también, o intentaré, cómo las herramientas de la archivística resultan cruciales en el tratamiento de documentos vinculados a delitos de lesa humanidad. Esta es la historia de la colección Guillermo Bernasconi y del proceso de profesionalización del Archivo Nacional de la Memoria. Justamente nos tenemos que situar en noviembre de 1982 en Argentina, cuando la dictadura estaba empezando a ser cuestionada justamente por el fracaso en la guerra por las Islas Malvinas y por las denuncias internacionales que recibían sobre los casos de denuncias de desaparecidos y la existencia de centros clandestinos de detención a lo largo de todo el país. En este escenario, las Fuerzas Armadas iniciaron un proceso de destrucción y ocultamiento de la documentación para garantizar su impunidad. Años más tarde se conocerán las órdenes formales justamente para la destrucción de documentos y cuando el objetivo estaba claro, que era ocultar los rastros de la represión y la desaparición de personas. En este sentido, acá aparece el protagonista de nuestra historia, que es Guillermo Bernasconi, que era un soldado conscripto de 19 años que estaba destinado en el Comando Primer Cuerpo de Ejército que quedaba en la ciudad de Buenos Aires, en el Departamento de Inteligencia. Él tenía una orden para poder salir de la unidad que le permitió justamente poder rescatar una serie de documentos que llegan hasta el día de hoy. Estos documentos, digamos, gracias a esta orden, cuando él estaba destinado en esta unidad, en noviembre de 1982, le ordenaron la destrucción de documentos, la quema de documentos en unos tachos en el fondo de la unidad, y gracias a este pase que él tenía, pudo esconder parte de estos fragmentos de documentos que él veía que eran documentos vinculados a organizaciones políticas, que decían que tenían sellos de estrictamente secreto y confidencial, y a través de detectar que esos documentos evidentemente por algo estaban siendo destruidos, pudo esconder algunas partes dentro de sus ropas y sus botas, y gracias a eso pudo preservarlos de su destrucción. Justamente en junio de 2021, Guillermo se acerca al Archivo Nacional de la Memoria y nos muestra que había guardado esas 539 páginas que pudo rescatar del fuego en una carpeta que decía Archivos de la Dictadura. Y acá estamos frente a nuestro principal desafío metodológico que tuvimos como profesionales del archivo, junto con una compañera, Aymara País-Negrín, que llevamos adelante en ese momento el proceso de normalización archivística del archivo, que fue justamente no dejar de entender que esos fragmentos, que esos documentos que estaban incompletos, no eran solamente fragmentos de documentos, sino que justamente tenían un potencial valor evidencial, incluso como posibilidad de ser aportados para la justicia, y que había que preservar justamente el relato vinculado de cómo esos documentos habían sido rescatados para tratar de preservar una cadena de custodia. En ese momento el Archivo Nacional de la Memoria, como dije, estaba atravesando un proceso de profesionalización y de normalización, y por lo tanto ya por suerte teníamos una política de acceso, una política de donaciones o ingresos documentales, un plan de preservación documental, una política de acceso también, que nos permitió afrontar con herramientas concretas cómo trabajar con esta documentación. Entonces, historiadores, archivistas, conservadores, nos pusimos de acuerdo para poder llevar adelante un trabajo integral que permitiera una digitalización, que hiciera una buena captura de metadatos, donde obviamente se trabajó a nivel de conservación preventiva, y comenzó una tarea de investigación específica que justamente nos permitió entender y reforzar sobre todo la primera etapa del tratamiento archivístico, que es la identificación. Entender que estábamos frente a una colección documental, una recopilación de documentos donde el productor de esa colección era Guillermo Bernasconi. Ahora, dentro de esa colección había unidades documentales donde el productor no era Guillermo Bernasconi, ese soldado conscripto, sino justamente el ejército argentino. A su vez, también empezamos una tarea en paralelo de investigación vinculada a las personas que allí aparecían, tanto a las víctimas como a los posibles perpetradores de esos crímenes, entendiendo que había que darle un tratamiento prioritario a esos documentos, ya que podían ser aportados en los juicios que ocurrían en paralelo y que ocurren hasta el día de hoy en Argentina vinculado a esos delitos de lesa humanidad. Y justamente hacer un trabajo profesional archivístico de descripción multinivel basados en la normativa, en las normativas propuestas por el Consejo Internacional de Archivos, y dar los documentos a la consulta a través de nuestro software Atom. En este sentido, resaltar la herramienta del Atom, que justamente permite ofrecer esos documentos de contexto, es la única manera que teníamos y la más útil para poder justamente explicar esta información, explicar cómo estos documentos fueron rescatados, cómo llegaron hasta el archivo, y poder entender justamente la diferencia entre lo que era el productor de esa colección y el productor de las unidades documentales. Incluso en este ejemplo que podemos ver en pantalla, es un boletín donde uno podría pensar que el productor es una organización o vinculada al Correo de la Paz, pero justamente el productor de este documento es el Ejército Argentino, el Comando Primer Cuerpo. Se pueden ver los sellos vinculados a que es un fragmento, un documento, que es un anexo dentro de otro documento general, que por más que no estuviera conservado en su totalidad, no deja justamente de ser parte de un documento que en algún momento el Ejército Argentino, un área de inteligencia, recopiló para justamente producir información e inteligencia vinculada con esa organización que produjo ese documento. Eso es un poco la intención que tenía de presentarles hoy, y justamente cómo la necesidad de registrar ese contexto de producción, de registrar la donación en el momento de hacer la donación. También hicimos una entrevista que pudimos filmar y que nos permitió justamente dejar registro no solo del proceso formal de la donación, sino también de la historia que estaban detrás de esos documentos, contada por el propio Guillermo Bernasconi, que es justamente lo que permitió dotar de autenticidad a esos documentos y poder justamente ser aportados como prueba en los juicios. En este sentido, la práctica archivística operó como un método de validación. Justamente los documentos vinculados con su paso por la conscripción, su orden de salida, forman parte hoy de la colección. No los separamos justamente porque son esos documentos los que también aportan autenticidad y permiten reconstruir la procedencia de estos documentos. En este sentido, resulta sumamente fundamental poder demostrar materialmente la veracidad de la procedencia de estos documentos y poder dar cuenta de esa cadena de custodia informal. Para finalizar, justamente teniendo en cuenta que estoy llegando hacia los 10 minutos que teníamos para poder presentar, no quería dejar de decir justamente cómo la disciplina archivística se vuelve crucial en el peritaje de documentos para poder ser aportados para la justicia. En Argentina a veces se ha dado este debate vinculado con las prioridades o la demanda de la justicia o la necesidad de aportar las pruebas, priorizando tal vez una metodología más del punto de vista histórico o del punto de vista de las ciencias sociales y no tanto de la necesidad de pensar el tratamiento integral de los documentos, de volver a rescatar sobre todo la primera etapa del tratamiento archivístico, lo que es la identificación, poder entender la procedencia de los documentos, entender quiénes son justamente esos productores y poder recuperar la historia archivística que está detrás. Justamente resulta crucial, sobre todo y principalmente en documentos que pueden contener información sobre delitos de lesa humanidad. En este sentido, también es un compromiso y una responsabilidad que tenemos los archivistas de poder entender que hay que darle prioridad al tratamiento de ese tipo de documentos para poder pensar justamente qué derechos están involucrados dentro de esas páginas. Pero no solamente entender y pensar una descripción archivística y una puesta al acceso desde la disciplina, entendiendo al documento en su contexto de producción, sino también pensar esa descripción teniendo en cuenta la necesidad y los posibles usos que esos documentos puedan llegar a tener, pero sin dejar en ese sentido de ser profesionales, de entender que los principios básicos, el principio de procedencia, el principio de orden original y las distintas etapas del tratamiento archivístico son fundamentales justamente para poder recuperar esas historias, poderles darle autenticidad y que justamente esos documentos puedan ser utilizados como evidencia jurídica. En este sentido, y sí, ya para terminar, no me parece fundamental poder seguir básicamente los principios de archiveros y gestores documentales en defensa de los derechos humanos del ICA. No hay nada nuevo de lo que les vengo a contar, sino es algo que ya justamente a través de la experiencia en el tratamiento de este tipo de documentos conocemos y están plasmados en esos principios básicos. Por último, y ahora sí para terminar, siempre tener en cuenta que a la hora de pensar el acceso y pensar la descripción y pensar el tratamiento de los documentos de archivo, tenemos que pensar en la triple función social y entender que los documentos justamente no solo son fuente para la historia, son también repositorios de la memoria institucional de las personas, instituciones, digamos, de sus productores, pero también son la garantía de derechos tanto individuales como colectivos. Y en ese sentido, la posibilidad de acceso a la justicia, la posibilidad de entender que que la disciplina permite justamente que fragmentos de documentos que fueron rescatados por una persona en una situación de extrema vulnerabilidad y de clandestinidad, hoy son un documento público, accesible y prueba en la justicia justamente gracias a las buenas prácticas de la disciplina y la posibilidad de un correcto tratamiento archivístico de la documentación. Ahora sí, muchas gracias.
Cecilia, muchas gracias. Thank you very much for your presentation. We have 2 minutes left, so I don't know if somebody from the audience have any question. I will give 1 minute. Voy a dar 1 minuto, Cecilia, por si acaso alguien tiene alguna pregunta. Igual muchas gracias por esa conclusión y creo que hay algo que oímos en la anterior presentación que el pensar en archivar por archivar es algo que no podemos tener solamente pues como parte de la práctica profesional. Hay muchas capas detrás de eso y sobre todo como la función social, lo que acabas de decir, que toca considerarse sobre todo al gestionar y administrar esta clase de archivos. No tenemos preguntas por el momento, así que mil gracias, Cecilia. So, in the interest of time, I think that we will now move directly to our next speaker, Joaquín Pinto Godoy, who will present the case study titled Document Management as a Foundation for Transitional Justice, Designing a Management System for the Archives of the Association of Relatives of the Disappeared in Chile. Joaquín, if you can turn on your camera, perfect. Thank you so much. So please go ahead. The floor is yours.
Well, give me a minute. So, well, good afternoon, everyone, and thank you for being here. I would also like to thank the ICA for hosting this session and giving me the opportunity to present today my research about document management as a foundation for transitional justice, the designing of a management system for the archive of the Association of Relatives of the Disappeared in Chile. To begin, I would like to clarify that I'm an external contributor of the Association of the Relatives of the Disappeared in Chile, or AFDD. That's the acronym in Spanish that I'll use along in this presentation. And this research is part of my master's degree in documentation and archives. And the goal of this project is to contribute to the archival staff in their current management plans. So for this presentation, I will introduce two series identified through this research that are directly linked to the legal actions and the formal proceedings of the AFDD's fights for justice. The AFDD was founded in 1975 by relatives of victims of forced disappearance during the Chilean dictatorship between 1973 to 1990. Through its social, political, and legal work, the association has accumulated textual, photographic, and audiovisual records that testify to its demands for justice, truth, reparation, and historical memory. So from its beginning, the archive was maintained by the association's own members without any archival standards. And so in that sense, the archive was not created by archivists. Instead, it was born by the urgent need to find their missing relative and a deep awareness that the documents were crucial evidence of human rights violations that were denied by the government regime. So to have some context, the first archival and major intervention took place between 2002 to 2010 by volunteers members of the association, driven by the inscription in UNESCO's Memory World Program and the support of the DAI program from Iberarchivos of Spain. And as a result of this process, 36 linear meters were processed out of a total of 80 linear meters of the font, with over 8,000 textual and photographic records being entered into a Winesis database. Then the archival processing was suspended until 2023, when it was declared as a historic monument by Chile's National Monument Council, initiating a new phase of preventive conservation and description of the undescribed portions of the fonts. So, given this context, two technical issues were acknowledged as needing to be resolved for the archival processing of the AFDD archive. First, although previous processing identified groups of records within the fonts, they have no functional links or no multi-level descriptions, only by descriptions by file or item, and also the Winesis database became obsolete and is no longer operational. So this has undermined the organization's capability to maintain control over its document, and that's a consequence why the access to the AFDD archive remains restricted. So this project addresses both issues by identifying documentary series and migrating existing records into a new database management system to restore the internal control and to sustain the ongoing description that the current archival staff is working on. So, as a result of this research, during the identification process, 6 core functions were recognized, which revealed 2 distinct pathways that the AFDD used to pursue its demand for justice. On one hand, we have the formal context that includes includes the internal administration, legal management, international relations, and the management of individual cases, like filing habeas corpus petitions, pursuing legal actions, and letters both sent to the regime authorities and international organizations. In the other hand, we have the informal context that covers social mobilization and public denouncement, and the informational outreach that were linked with direct actions like street protest and hunger strikes, and also protests in which participants change themselves to public buildings. And this is related with a significant volume of records, including public communications, monitoring reports, and solidarity correspondence. For these presentations, I will focus on the association's formal procedures, and I would like to highlight that these formal procedures and the records created from these formal procedures in the archive reflects the organization's own evolution from its early formative years, and expresses also the transition from each member's individual search for their missing relative to a unified and collective demand for justice. So we have two series linked to this transitional justice process, and it's in its origins, following the arrest of the relative, each member began searching for them individually. They visit various detention centers and exchanging information and advice with other families about where to turn for help. And a vital point of contact was the Pro-Peace Committee, where families could file individual appeals and habeas corpus petitions. So later on, as these families began to meet collectively, they decided to unify their efforts and compile the first official list of victims of enforced disappearance, which were then sent to international organizations and presented to courts of justice. So to be included on these registries, a baseline set of legal documents was strictly required, most notably a previously filed of habeas corpus petition. And as Norma Gloria Rojas explains, an early member of the association, to them the habeas corpus was fundamental, and it was like a baptismal certificate. So filing this habeas corpus petition triggered the opening of a case files, and this was the origins of the earliest documentary group, that is the Files of Victims of Enforced Disappearance series. And this series also contains a diverse type of records, from judicial proceedings and kidnapping testimonies and vital documents like birth certificates, marriage certificates, employment certificates. And so these files in one way serve to reconstruct the context of the state repression, and also serve as a vital safeguard for the fundamental rights of each victim, certifying their identity, their citizenship, and their life experience before their forced disappearance. This individual case-by-case approach eventually evolved into a collective legal action, giving rise to a second series, that is the habeas corpus for mass disappearance series, which brings together approximately 66 documents. And in May 1975, the AFDD filed its first collective habeas corpus petition with the Chilean Supreme Court, and it was the first of many, and it marked the transition from individual grief and search to an organized and documented demand for justice. So the final component of this project addresses a practical objective, that is to recover the legacy of the Winisis records and the design of a new management tool for the archive that we call CIDARC, or Archive Description System in Spanish. And the platform recovers and centralizes all records from the obsolete Winisis database, integrating this previously inaccessible description into a clear hierarchical structure for the first time, based on the ISAT standard, and also based in the previous identification of series that we saw earlier. So ultimately, CIDARC is a local server app that is designed to streamline the internal management of the AFDD archive, and laying the groundwork for a supervised public access and continuing the AFDD contribution to Chile's ongoing transitional justice process. So the final reflections of this work is that by drawing the organization's history and retrieving information from an obsolete database, this project identified 2 documentary series directly linked to the formal pursuit of justice during the dictatorship in the association. So creating and compiling documents was a fundamental step for the AFDD for its struggle for truth and justice, and the association systematically documented every action taken to investigate human rights violations and providing critical evidence during Chile's transitional justice process and to the truth commissions. So this opens the door to analyze how the Chilean justice system operated under the regime, and also prompt us to look for the records within that are in the AFDD archive that reflects the direct experience of how justice was applied or failed to be applied in the transitional justice context. So, why to discuss the formal search procedures of the association? I think that is a good example of how, despite the dictatorship's attempts to destroy the rule of law, every legal action, letter, and document file of the association that appeals to the state institutions, in a certain sense, it was a way to restore the rule of law, and during the dictatorship and also in today's democracy in Chile. So thank you, and here you have my email address if you want to take some questions furthermore.
Joaquín, thank you so much for your presentation. We just invited the audience to add their questions in the Q&A box. So while we wait, I would like to mention to everybody that this is our second case study virtual session. In less than 30 minutes, we will have our third one. So you are more than welcome to join us. So let's see, I'm just checking the chat box. But well, knowing that we are passing some time of the end time, I would like to thank you all. Joaquín, thank you again. I think that with these 4 presentations, we have learned a lot about how archives contribute to accountability, transparency, the guarantee of for protecting human rights. So I hope that you can still join us in all the activities that the ICA has prepared to keep the discussion around the topic of this year, that is Archives for Justice. So knowing that nobody has had any questions or comment, I will then thank all the participants who join us today around the world. And if you have enjoyed today's session, I encourage you to continue exploring the activities, resources, and events available to the ICA website, where you will find all the webinar programming, also the content hub that we have prepared with different resources connected to this year's theme. So please check our website and also follow us on the different social media channels that we have right now activated with different content for you to read and explore. Finally, on behalf of the ICA, thank you again to our speakers, to our participants, and with no further ado, have a wonderful day, afternoon, or evening, wherever you are joining us. So goodbye, everyone.